Thank you, and I also want to join in the previous speakers' thanks to the organizers of this symposium, and the invitation came at a particularly good time for me. The information yesterday from the panelists and the discussions was very helpful to a project I'm working on, so I appreciate all the insights, and hopefully I can also provide some thoughts to add to the discussion. What I want to start with is sort of setting the stage about the environmental issues facing Indigenous people. In 2016, the world's attention was riveted by the controversy unfolding at the Dakota Access Pipeline, which is near the Standing Rock Sioux Reservation. Activists from all over the world poured into the camps to support the tribe's efforts to stop construction of an almost 1,900-kilometer pipeline. The pipeline, these are the 4 states that the pipeline crosses. Here's a closer view of those 4 states. The pipeline is designed to carry oil from the Bakken oil fields in the northwestern part of North Dakota to a tank farm in southern Illinois. And it passes in between the Standing Rock Reservation and the capital city of Bismarck. When the pipeline was originally proposed, and that red blob is Bismarck, the pipeline, and I'm sorry, my slide didn't come out here, but the original pipeline went north of the city. And when the city residents protested that the pipeline might leak and contaminate their water supply, and it needed to be moved. So they moved it to an alternative route, which doesn't run through the Standing Rock Sioux Reservation, this gold area, but runs immediately north of it. And it does run through lands guaranteed, the blue lands were guaranteed by treaty to the quote-unquote Great Sioux Nation, which includes the present Standing Rock Sioux tribe. And those lands were unilaterally and wrongfully taken by the United States government. And that's not my opinion, that is actually a holding of the US Supreme Court. So the protests came after the Standing Rock Sioux tribe filed suit trying to stop the pipeline, asking that it be halted until the process complied with federal law, which requires a certain informed decision-making process and consultation with tribes. The Obama administration agreed to halt construction pending proper completion of the administrative processes. The Trump administration immediately restarted the project within days of his inauguration. And the court had found problems with the process, but allowed the construction to be completed. And the pipeline has leaked twice, although not under the lake or the river that's near the reservation. This story should be familiar. This has been all over the news, but there's some parts of it that perhaps are not as familiar. And the question becomes how to make that change. Do you make it in dealing with the administrative agencies? Do you make it in working with the legislature? Do you make it in the court system? Because Standing Rock tried all 3 of those. And despite the fact the law was on their side at every single step, they lost. And that pipeline, as we said, has been completed. And this is not just a story of Standing Rock. One reason that the world coalesced around Standing Rock is it's a story that's repeated around the world. Standing Rock and the Dakota Access Pipeline are just one example in a long line of environmental challenges that are facing Indigenous communities around the world. Those challenges take a number of forms. And one typical form is that Indigenous peoples' lands have been seized, as we've heard earlier, for other uses which are often incompatible with traditional subsistence practices and other cultural practices. And these appropriations are not always the centuries-old byproduct of colonialism. Just last month, 4 weeks ago, the Tanzanian government gave notice to a Masai community that was located near the Serengeti National Wildlife Park that they had 5 days to vacate their ancestral grazing grounds, land that provides critical sustenance to their cattle during the dry season. When the village had not vacated within the 5 days' notice, the government evicted them by burning them out of their homes. And this land, the reason they're being evicted is the land is going to be turned over to a luxury big game hunting firm out of the United Arab Emirates. In 2014, the US government passed a statute agreeing to swap land from a national forest with land owned by Resolution Copper Mine. And this land, the national forest land, included land that was sacred to the San Carlos Apache tribe. And the federal statute allows for a copper mine to be dug 7,000 feet down into the earth. That's 2 Ben Nevises stacked on top of each other. Now, this project has not gone forward yet. The land has been listed under a provision in the National Historic Preservation Act, which does not bar the mine, but does require extra decision-making processes. But these are the same processes that were skipped in the Dakota Access Pipeline situation. At numerous places around the world, hydroelectric dam projects have interfered with the life cycle of salmon, disrupting their ability to return upstream to spawn. These projects not only deprive indigenous communities of subsistence fishing rights, they impact cultural practices. And these cultural harms are often discounted or considered as less important than quantifiable economic harms. The U.S. Forest Service is under a statutory duty to manage lands for multiple uses. There's a ski resort in a national forest that wanted to expand and to create artificial snow. And they needed water to make the snow. So they proposed bringing a pipeline up that would bring reclaimed water up. And this 3 area tribes protested, saying that these lands would be contaminated, their sacred lands, the homelands of their gods, would be contaminated by this reclaimed water. The Forest Service allowed the project to go forward, arguing that the economic benefits to the surrounding community far outweighed any cultural or religious harms to the indigenous communities. Even when a tribe or an indigenous community can prove quantifiable economic harm, that is often not enough to prevail in litigation. The U.S. government acts as a role of trustee for many tribal lands, so it negotiates the deals on behalf of the tribes with the mining companies and the mineral extraction companies. The U.S. government negotiated a deal with Peabody Coal on behalf of the Navajo Nation that called for a royalty rate that was substantially below fair market value and substantially below the minimum permitted by federal statute. The Navajo Nation filed suit, arguing a breach of the trustee's duty. After several trips to the Supreme Court concluded the litigation by ruling that because the tribe cannot identify a specific applicable trust-creating statute or regulation that the government violated, we do not reach the question whether the trust duty was money mandating, whether it specified the quantity of royalties. Thus, neither the government's control over coal nor common law trust principles matter. So unless the government passes a statute that says we must behave ethically, they're not required to do so. The Niger Delta is home to many ethnic groups and to the oil that constitutes 80% of Nigeria's income. The Nigerian government seized this land from the ethnic groups that live there, declared that the compensation they would pay is limited to the surface value of the crops that were grown on there, and invited oil companies in to explore. The area has suffered massive oil spills. Some estimates are 50 times the Exxon Valdez oil spill. And these obviously have direct impacts on flora, fauna, and the health of the indigenous peoples who live in the Niger Delta. As this example illustrates, the indigenous people who live in these areas often suffer a far disproportionate amount of the cost, and they bear very little benefit, or they participate in very little of the benefit that's obtained. And this is Tar Creek on the Quapaw Reservation in Oklahoma in central United States. That obviously is not the natural color of a river. That is contaminated with zinc and lead mining, and it's been the subject of cleanup for 40 years and is still not cleaned up. Chemicals, or the Navajo Nation, the coal mining that was done by Peabody on Black Mesa, the techniques they used, both emptied the aquifer and contaminated the aquifer so that the residents of Black Mesa have no safe drinking water. They have to truck in drinking water. Chemicals from various manufacturing byproducts and pesticide runoff have contaminated rivers throughout the United States, resulting in incredibly high levels of mercury in some fish and in contaminating the rushes, which then make them unsafe to gather and weave into baskets. I know this, the fish, you're too small to read the names of the fish, but the important thing is actually the 3 color bars at the bottom. The green one says this fish is safe to have 2 servings of a week. The yellow bar says 1 serving per week of these fish. And the red bar says these fish are not safe to eat. Well, indigenous communities whose subsistence centers around fish eat far more than 2 servings of fish a week. So they're ingesting toxic levels of mercury. And one author said they must they've been given a choice to give up their culture or their health. And the Kumaya and the Tahana-Atum tribes, which are both basket weaving tribes, and are each divided by the Arizona, one's divided by the Arizona-Mexico border, one by the California-Mexico border, have discovered that addressing pollution is incredibly complicated when it crosses an international boundary. And when you add in the border management area, which is the lighter yellow area, it gets even more complicated. The Gwich'in people of the Arctic also discovered this with respect to the porcupine caribou herds. The porcupine caribou herds have a very large migration pattern, and their calving grounds are in the Arctic National Wildlife Refuge. And so the herd management is split between the US, Canada, and the Gwich'in management. And obviously this has been very confusing for who's going to have jurisdiction over the porcupine caribou herd. I could go on and on with examples, and I haven't even touched 3 categories of overuse or exhaustion of resources, resulting in rationing, such as of whales or seals, incompatible farming techniques, such as indigenous slash and burn agriculture in the rainforest in Latin America, and the intellectual property tensions with manufacturing, agriculture, and pharmaceutical companies, and traditional ecological knowledge of plants. So as you can see, it's a wide variety of challenges. It's not just mining. It's not just mining exploration and extraction. And indigenous people, in seeking to remedy these harms and to confront these challenges, are seeking to regain control over their lands and territory, access to their sacred places, an effective voice in decision-making processes, and an efficient and effective voice in dispute resolution and judicial forums. And in setting these goals and in seeking these goals, the indigenous communities strive to protect their identity and their culture and their way of life. It does no good to gain a seat at the table if the cost is your culture and your identity. So there have been lots of examples used throughout this symposium, and lots of attempts over the last 20 years at national and international levels to address these issues through various agreements. My focus today is not on these agreements themselves, but on the use of customary law, both within and without these agreements. And so I want to turn to looking at categories of approaches that indigenous people have used to incorporate their customary law into resolving these challenges. Before I do that, 3 quick cautions. We need to avoid sort of the noble savage romanticism that indigenous people are all about the land and all about protecting the land. That's true of some groups, but not others, and it's true in varying degrees, which leads to our second caution: avoid pan-indigenous homogenization. Within the United States, there are 557 federally recognized indigenous groups. Some are related to each other, some are not. You spread that around the world, and you've got exponential number of indigenous groups. Some are nomadic hunter-gatherers, some are farmers, some have irrigated agriculture, some are fishing tribes, some are hunting tribes. There's a wide variety of indigenous groups, and we have to be careful about painting them with one broad brush. And we have to avoid what's called the menagerie theory of indigenous peoples' law. This is the freeze framing of indigenous cultures at a particular point in time. to be a viable culture, you have to be able to grow and adapt and change. And an example of the menagerie theory is a tribe that was told it would be allowed to catch a whale if it used oars and a canoe and a spear. They could not use a harpoon or an outboard motor because that would mean they weren't really Indian and they weren't really hunting in the indigenous ways. So how do indigenous people use customary law to address these challenges? I have 6 categories that cover the spectrum of approaches. You will see not all of these have very scholarly names. I tried to pick names that I knew we would have to go fast today, that would sort of resonate and distinguish from each other. So what I want to do is give one example from each category. The plug-and-play approach is where the law is designed to accommodate a local law to be put into it. And so indigenous people can put their law in just as states or other groups can. For example, in the United States, pollution control statutes set a range of water quality and give each state the ability to pick where in that range it's going to establish its water quality standards. And indigenous groups can qualify for what's called treatment of states or TAS status, which gives them the same ability within the reservation boundaries to set the water quality standards. The Isleta Pueblo qualified for treatment of state status. They picked the highest possible water quality standard because they participate in ceremonies where the people are in the river as part of the ceremony. This was higher than the state of New Mexico had selected, and the Pueblo of Isleta is located immediately downstream of the city of Albuquerque. So the city of Albuquerque was now passing water downstream that violated the Pueblo's water standards and was faced with building a multi-million-dollar water treatment plant in order to satisfy the Pueblo's water standards. They filed suit alleging they shouldn't have to do this, and the court said, that's the law. That's the way the legal system works. The tribe qualified to apply its law. Just because it picked a higher standard than your state did doesn't matter. You're still passing dirty water. You have to clean it up. What I call the private property approach. And in this approach, the indigenous group uses the legal system to gain control of a particular land or territory. This can be the native title process in Australia. This can be the federal recognition process in the United States, or the equivalent in another country. Once they gain control as if they were the landowners, or just as the landowners, then they can use their indigenous customary standards to develop the management principles and the governing principles for how that land will be used. For example, the Gunditjmara group created the Gunditjmara Traditional Owners Corporation when they won their native title claim. And they've established an indigenous protected area for plants and wildlife. And that they manage that according to World Conservation Standards and using their own principles. A related approach, again, is the local knowledge approach. This is not so much using indigenous customary law as indigenous knowledge of the plants or animals or fish. In this case, I draw this article from this example from an article that was written in 2012 that compared salmon restoration techniques. And it picked 2 river systems, the Tana River in Norway and the Columbia River in the Pacific Northwest. And on the Tana River, the government set uniform standards based on biological diversity and preserving biological diversity. And there was no special role for the Sami in administering those standards, even though the salmon were a major part of their culture and their way of life. In the Pacific Northwest of the United States, the Nez Perce tribe used its sovereignty and its treaty obligations to carve out a right to run tribal hatcheries. And it's still early days, but the evidence is showing that the tribal hatcheries are having significantly more success than non-tribal hatcheries at reintroducing salmon, and salmon that is genetically similar to the wild salmon. So that prioritized cultural diversity. And so the question of this article, which the article didn't answer, is how do we decide what the priorities are? And that maybe there needs to be room for the indigenous group to use its knowledge of the area. The next approach, called the Schrodinger's cat approach, because it's both existing within and without the system at the same time. I know the cat's supposed to be in the box the whole time in the Schrodinger's cat theory, but there's cats in two mutually incompatible states of being. And it should be mutually incompatible to be both within the legal system and operating outside the legal system. The example of this is an indigenous group, an Aboriginal group in the state of South Australia called the Ngarrindjeri. The Ngarrindjeri had a terrible polarizing experience with the federal government of Australia. If we have any anthropologists in the room, this is the Hindmarsh Island situation. And this is the group involved in the Hindmarsh Island case, which fractured the relationship between the Ngarrindjeri and the Australian government and fractured the Ngarrindjeri themselves. And they said, how can we get past this? How can we put things back together again? And they said, we are not dealing with the federal government anymore. We're going to negotiate local contracts with local government and with the state government. And we're going to use private contract law. We're opting out of the whole law dealing with Aboriginal and Torres Strait Islander people. This has been incredibly successful for the Ngarrindjeri and the state of South Australia. The Ngarrindjeri, by contract, define cultural knowledge, define who gets to see what levels of cultural knowledge are contained in reports, and get to define what the dispute resolution process is. As a result, for example, the traditional custodian of one site and the state park warden of that site are one and the same person. So she's managing the site according to both state and traditional standards. This has been so successful for the state of South Australia that they have asked all other Aboriginal groups in their region to organize in the same principles and in the same way. So this is really thinking outside the box to come up with a solution that works well. And then there's what I call the Scottish preposition approach. I've been working for the last 3 years with a law professor at the University of Leeds who is Scottish, and she taught me this new wonderful preposition that I didn't know before, out with. So I like it here because it has double meaning. It's working outside the system, but it's also out with the system. It just tosses the system out on its ear. And the indigenous groups using this approach are usually hoping either to fly under the radar or to get post hoc ratification of what they do. And the example is an indigenous group in Alaska. A native village in Alaska was having terrible problems with the hunting camp during hunting season that would form immediately north of the village. The hunters dumped their waste and their trash in the river, which contaminated the village water supply. All of the hunters' actions violated camping regulations and U.S. Forest Service regulations. And the village asked the Forest Service to enforce the regulations. And the Forest Service said, we're stretched too thin, we're sorry, we can't do anything about it. So the village was having one of these hand-wringing sessions saying, what can we do? If we file suit, what do we do? And someone said, we're government. And they went on the internet and bought police badges and citation books and went out and started ticketing the hunters. And after a couple of years, they pretty much cleaned up the problem. And the hunter then sort of went, do you have the authority to do this? And went to the Forest Service and said, I don't think they should be doing this. And the Forest Service says, well, we think it's working pretty well. And by the way, you should stop polluting and pay your damn ticket. A colleague of mine calls this the Nike approach to sovereignty. Just do it. And the last example I want to give, and I'll make this very quick because I do want to run through just a couple of quick slides after this, is where we use the indigenous people's dispute resolution mechanisms as opposed to their substantive customary law to create a forum and a mechanism for resolving the dispute. And I won't go more than that, but anyone afterwards that wants an example, I'll be happy to give you an example about management of sacred sites in the U.S. using this approach. The common themes, if we look back at these 6 approaches, show that 2 things existed in every approach where there was success. There was some sort of cultural interpreter or cultural process whereby each side could understand what the other side was claiming and arguing. This goes back to something Natasha was saying about understanding your filter and your perspective and being able to see the other side. And in every one of these, they were able to find mutual self-interest, which means a lot of these solutions were localized. They were done by the people on the ground having to live with a situation when the lawsuit would be over and done with. But there are also some elements of concern with these. Often they're premised on one person being able to, and willing to look at things differently. What happens if that person is not there, that person leaves, or that person changes their mind? And it often is premised on the indigenous group surrendering some prior gains in authority or sovereignty. What can those be regained if everything starts going sideways? And the last use of indigenous customary law I want to point out is actually in the classroom. It's a major factor. It's changed the way I teach over the last dozen years. I've been teaching for almost 25 years. I'm working in Indian country in the United States for 25 years. And over the last 12 years, the way I teach has changed dramatically, both as a result of my work in this area and the changing demographics of my graduate students, with many more indigenous students coming through my classrooms. I am no longer the sole or even the most knowledgeable expert in the room on many topics. I view myself sort of as the air traffic controller or the architect, figuring out what's the minimum necessary for everybody's safety, and then what's changeable. And then I facilitate discussions on those. It does require knowing and understanding how to teach a diverse classroom. And I don't have time, I'm sorry, to go through this, but I'm happy to talk about it with anyone. But why make the switch? It's a lot of work. I hardly teach any class the same twice. There are core bits that are taught the same, but things change as it evolves. But it's much more interesting for me as a scholar. I delve into deeper questions of law and more theoretical questions than I used to. I'm not quite as practice-oriented as I used to be. But it results in better prepared graduate students, which results in better results for indigenous communities. So I think the answer for me is, why wouldn't I make the switch? Because this is, again, finding the self-interest for all three groups. And this is where I think figuring out how this plays out on the global environmental stage can help improve things. Thank you.